Yes, I'm Adam. I'm, as I say, barrister at Harcourt, so that's a family set of chambers. So if there's any of you budding family barristers in the audience, you've got any specific questions for family applications, go ahead and put those in the Q&A box. And if we've got time, we'll definitely come to answering some of those. So I'm going to go round the sort of robin of panelists we've got in front of us today to do a very, very quick introduction of who they are, where they're from, and what area of speciality they're in or going into. So we'll start with Jim.
Thank you, Adam. So my name is Jim Hirschman. I am a barrister at 3 Paper Buildings, specialise in public and family law. And just a little bit about my journey to get to the bar. It took me about 10 years all in to get pupillage, but I had a slightly roundabout way. I did a 4-year undergrad at Westminster University with a year in Berlin on exchange. I then spent a year in my students' union before then doing a master's at UCL. I then went on to do the bar course, and it's during the bar course that I got pupillage at a common law set. I then had a filler year, and in that year, I was an advocate with LPC Law, and I was also a visiting lecturer back at the University of Westminster and a tutor in law. So that's broadly my route, but I'll be unpacking some of the virtues of the filler year in due course, and look forward to coming on to that later.
Thank you, Jim. Moving next to James.
Hello, everyone. So my CV to date is really that I studied history at undergrad, and then I worked for a year in a think tank. I then did the GDL, and I then moved on to working in the Court of Appeal as a judicial assistant, and I'm now a research assistant at the Law Commission. I should make a disclaimer at this point, which is that I haven't actually got pupillage yet, but I'm here really to tell you a bit about the judicial assistant role and the Law Commission research assistant role, because they're both quite popular jobs for people who are looking to pursue a career at the bar. And they are very interesting and fulfilling jobs which can lay a good foundation for practicing at the bar. So please ask me all questions you have about those 2 jobs in case you're interested about them, and I will do my best to answer them.
Thanks a lot, James. Olivia, your turn.
Thanks. So my name is Olivia English. I am currently a research assistant at the Law Commission as well, but I work in the criminal team. A sort of potted history of my career to date. I studied law at the University of Nottingham, and I graduated a few years ago. I then went to work for a charity called Amicus for a year, and I then did a master's in human rights law at Queen Mary University, which I did part-time over 2 years, and I worked as a paralegal for those 2 years at a barrister law firm called Brightline Law, where they specialised in financial crime, and so I assisted with all the work that they were doing in financial crime. I then did the bar course at the ICCA last year. Now I'm at the Law Commission, and I start a criminal pupillage in September at 23 Essex Street. So I'm happy to answer questions about anything criminal that I can help with, but any of that as well.
Great. So as promised, I think that we will broadly start with going one by one across our panelists, who will give you a bit more about their history in more detail, but also mostly focusing on the jobs that they've done between their time of studying and into pupillage, to give you guys a bit of a flavour, because I've seen some pre-submitted questions which I've gone through with the panelists already. So if you've already submitted a question before today, that's very helpful, thank you. And we've all read them. So we'll do our best to pepper in some answers to those questions as we go through, but certainly definitely make use of the question function that Clara drew your attention to earlier on. Please make sure you don't send questions in the chat. It's definitely, there's apparently, I'm told, a separate button for sending questions. So yes, with all that out of the way, Jim, if I can put the spotlight on you first, to go ahead.
Yeah, thanks. So the first time I applied for pupillage was during my master's, and I got the grand total of 0 interviews in that round, which was an encouraging step as I took the plunge into the bar course. But I did manage to get some funding for the bar course through a scholarship, and it was during that year that I really focused on my application. I'm afraid I can't remember precisely how many interviews I ended up getting, but it was something like 10 first rounds, of which I converted half into final rounds, 1 into an offer, and a couple into reserves. But the advice I got was, 3 to 5 final rounds tends to convert to an offer from a very good careers advisor who was live at the University of Law. And I make that point, I think, to show how much of a difference a year can make. It can be very much the case that you're just on the cusp and just 71 out of, I don't know, the top 60 who get the interview, so 11 places off, and moving up those 10 places, or 12 places if you can be strict about it, really can be done quite quickly, in my view. That's the first point I make. I think the second point I make, which I think is really important to realise, is that whilst getting pupillage, getting tenancy, and starting a career at the bar is exciting, and I certainly think a good thing to pursue, it's not unique in that you can do the job of a barrister in many ways, or job similar to that of a barrister in many ways, without having pupillage. And that's certainly the view I took. So in the early stages, you can do debating at university, you can do mooting. Admittedly, you're not paid for it, but you can take part in pro bono projects, the free representation unit, for example, in employment tribunals, and you start to really apply that learning, applying those skills in a practical setting. And once you've done the bar school, some doors open, and one of those doors is LPC law, and that's what I did. And my view was, if I didn't get pupillage during bar school, I could spend 2 to 3 years, certainly, quite merrily, doing things like LPC law, building the skills that I build in early practice anyway. And my thinking was, well, if I do that for 3 years, I then get pupillage, I suspect I'll progress much quicker when I finally get to the bar. It won't be time down the drain. And in the end, it's what I wanted to do anyway. And so I thought, if I can get in front of judges and do some advocacy, then I'm probably living my best life. So starting with LPC law, why do it? Perhaps what is it? You act as a county court advocate. That means there are certain areas in which you're able to act on behalf of clients, provided that it's in chambers, in private. And the first thing that allows you to do is advocacy, real advocacy in front of real judges on real cases. And some of them are very small, some of them may be as little as handing in a consent order and saying to the judge, here you go, here's an order, it's all agreed, thank you very much. But you progress from there into slightly more complex matters, which I'll cover shortly. But the first point is that becoming comfortable with a judge, becoming comfortable in that forum, in that environment, particularly if you have a client with you, particularly if you're acting against counsel or against litigants in person, as the case may be, knowing how to handle yourself, I think gives you an enormous advantage when you start pupillage. And certainly when I got into second six, felt very much at home when I started appearing before district judges again. So advocacy is the first point, the first reason to do it, to develop the skill that you need to deploy as a barrister. Obviously, it would help you in interviews if you're able to draw on your experiences of applying for CPR and practice in those interviews. The second reason it's good is because it gives you an insight into what I will call self-contained packets of law. So I remember the first thing I ever did was an infant approval settlement. So essentially, you go into court with an advice from counsel from a solicitor as to what the claim of the value is, and your job is to take the client through it, make sure the right paperwork is filled in, and then when you go into court, making sure that the relevant parts of the CPR are met so that the order can be approved. And so because it's an infant, the court needs to approve an order like that. You can't just settle on behalf of the minor without the court approval in those circumstances. So that already gives you an insight into personal injury, very much into the sort of documents that you'd be dealing with if you were doing low value RTAs, road traffic accidents, where you're dealing with medical evidence, for example, and the sort of correspondence that you have between insurers relating to that. So for any civil pupillage, a common law set or otherwise, you can immediately see the benefits that it has to have some first-hand experience of the practical implications of that area. You're supervised, of course, by the firm, LPC Law, so there's senior solicitors there you can speak to get advice and to make sure that you're on the right track. But it is a lot of self-disciplined learning, if you like. There's a handbook that gives you the rundown of most likely issues that are going to crop up and of the law, and you can, of course, do your additional research on top of that. Beyond RTAs, you also deal with bankruptcy petitions, or I did in my time, debt enforcement, charging orders on property, for example. And that, interestingly, I thought and think now gave me an interesting insight into social justice. So a case that I'm doing now, for example, regards a special guardianship order, which is where a family member agrees to essentially act as a parent, where the birth parent, if you like, are unable to do so, and care proceedings have been issued. And one thing that local authorities have there is certain duties to give financial support to the special guardian. And the question is whether that's been properly calculated. In my case, it's led to my client accumulating various debt over a number of years, which we're now trying to recoup from the local authority. But the reason that the bankruptcy work and the debt work is important is because a lot of her debt has been frozen, sold on to debt enforcement agencies that are then going after her. And having some familiarity of how that works in practice and how these kind of groups enforce that debt has actually been really helpful in this pro bono case that I'm doing, even though it's in a completely different context. So again, that crossover, but just understanding the bread and butter mechanics of how the justice system works right from the bottom up, I think is really, really valuable. And I'm certainly very, very glad that I spent a year doing it. Once you've done these, I will call them basic applications because they don't generally last more than 15 minutes, the ones you do at the start. There was, when I was doing LPC law, scope to move into the small claims arena, and that's when you start doing road traffic accidents, basic contract disputes, often arising again from debt enforcement companies when I was doing it. So you'd have a dispute about the enforceability of a debt, whether it properly accrued, and whether the debt that was purchased by the company has any value, whether it's properly assigned, all of the basic contract questions that I hear others doing civil pupillages, civil practices, wrestling with every day, albeit now at a level slightly beyond what I was dealing with as a county court advocate. So I think that gives you an insight to some of the areas that you learn and some of the value from that. I note I'm coming to the end of my time. So I'll end by saying one final thing, and that's the independence of being an advocate. You're self-employed. The work you do is very much up to you. You can take your prep days, take holidays when you want, and you eat what you kill, if you like. So the cases you do are what you're paid for. And if you are not sure that that's for you, I think it's a good testing ground to see whether you like it, because although much less well remunerated than the bar, I think it's a very realistic insight for managing your own practice. So that I think is my 10 minutes and all I have to say on LPC law, but I'll pass back to Adam.
Thank you very much, Jim. We've had some very helpful questions coming in the Q&A chat box, some of which are relevant from now and some are definitely relevant for later on, so we'll come back to some of them. But a really interesting one comes from Ben. He asks, if you're working in a full-time position, undertaking advocacy daily, Is it still worth seeking out mini pupillages and mooting opportunities, etc.? So Jim, I wonder if you can give some insight into that question.
Yeah, so I think mooting probably less so, although if you don't have any moots on your CV, I'd probably say it's worth doing one, perhaps, but I'd say you're probably moving beyond that. In relation to mini pupillages, I think absolutely, and the reason for that is twofold. One, you want to understand the culture of the chambers you're applying to, and second of all, you want to get exposure perhaps to areas outside of that which you're working in week in, week out, even if it's in the same area of law. So if you're, I don't know, working every day doing civil advocacy, you might want to get exposure to what it's like 5 years, 10 years, 15 years in, and then mini pupillage gives you that, and again just adds a string to your bow on your CV and proving that you're really committed to the bar.
Thanks, Jim. And certainly, one of the questions actually was, or pre-submitted questions, I should say, was in relation to how one could demonstrate an answer to why have you picked these chambers. So one of the question was, what do you include in the box when asked, why have you picked these chambers to apply to? So Jim, I'm sure you'll agree with me that actually it's quite useful, isn't it, when you've done a mini pupillage either at a chambers or at a similar set of chambers, preferably in the area of law that you're looking at, that a mini pupillage is probably the most accurate way of being able to say, well, these chambers and this specific barrister really inspired me for XYZ reason. So that can quite help in relation to that, I assume.
Yes, no, I entirely agree with that. I would associate myself with those comments.
Great. Thank you so much, Jim, for your insights into becoming a county court advocate. We'll come back to you, of course, in relation to more questions that I'm sure we'll get in relation to the actual application process itself. But in the interim, I'm going to mix up the order a little bit and jump to Olivia now to talk to you about her role as a legal research assistant at the Law Commission, as well as her journey more broadly to pupillage. So Olivia, fire away.
Absolutely, thanks. So I'll talk a bit about what I do at the Law Commission first, and I gave a sort of very brief overview of what I'd done before that, and then I'll highlight a couple of other things that I felt were really helpful for me in getting pupillage, because similar to Jim, this is what I'm doing post getting pupillage. So the job of a research assistant, in terms of what I do sort of day to day, the main things are legal research, legal analysis, so in writing memos and notes and things like that, engaging in what members of the public think about the law that we are examining, and what academics say, and what we think, and what the sort of hurdles are and the problems are and things like that. I work on a project looking at corporate criminal liability, so I've been engaging lots with what prosecutors think, what academics think, and talking with members of the team about what the practical implications might be of the things we might propose to reform, why they need reform, whether they need reform actually before that question, things like that. So it's quite theoretical, which I love, because I have been able to understand this area in more detail than I think I would have in many other arenas, and it's something that I'm obviously very interested in. And the range of projects that the Law Commission does generally means that there's quite a broad scope for people to explore things that they are very interested in. So just to give a sort of flavour within the criminal law team, and James can talk more, I'm sure, about his team, but across the criminal law team, some of the projects we're looking at the moment are intimate image abuse, so making and sharing images that are intimate, and what the criminal consequences of that could and should be. So things that most people will be familiar with from the news are issues like upskirting, which has already been made a criminal offence, and to what extent that sort of regime should be expanded. What happens to intimate images that are shared, which is obviously a very serious issue. There's a new project looking at evidence on serious sexual offences, so examining previous sexual history evidence and things like that. There's a project on confiscation, which is perhaps slightly less exciting. So there's quite a broad range, and a range of skills that you use within that, which I think make it quite well suited to people who are interested in a career at the bar. So the research, the ability to understand relatively complex areas of law, but then explain it in a way that a wide sort of audience of people could understand, which is obviously a really important skill for a barrister. And being able to write coherently, being able to work with people, and sometimes having to work to fairly tight deadlines. So there are lots of things that I think can be picked out as sort of very relevant to those applying for pupillage. I can talk about the application process. I'm not sure how much detail would sort of be useful, but it's a relatively straightforward but requires a bit of time application form, a written exercise, and a relatively long interview. I did my interview last year when I was also doing pupillage interviews, and I had been used to first round interviews, some of which were 10 minutes for criminal sets. And I think my law comm interview was 40 minutes and I was exhausted at the end, but a fairly standard sort of questions for me, with some legal analysis, which was useful. I'm not sure how much time I have left, but I thought I'd just highlight a couple of other things that I relied on in my pupillage applications that I found really helpful. One of which is my paralegal job that I mentioned before. I worked with a group of barristers and did a lot of legal research, but also helped them prepare cases and things like that. And it struck me that it might be useful because I saw the questions about mini pupillages, and I didn't do very many at all. But obviously this particular job happened to be working with barristers rather than solicitors or anyone else. So when I was sort of trying to convey things like why I wanted to be a barrister and what I understood about the bar, I relied on that. Where if I didn't have that, I think mini pupillages probably would have been really useful. So I think there's not necessarily a one size fits all answer, but I found it really helpful when applying to look at my CV sort of in the round and think about it's more than a box ticking exercise, but in a sense, what boxes I could tick sort of an evidence with the experience that I had. And then make adjustments and sort of present it in the right way, depending on what, based on what I had done. So it's sort of a thing to be assessed, I think. So those were two sort of like very formative experiences that I had that were incredibly helpful. Oh, and I wanted to highlight one more. I volunteered when I worked at Amicus. I also volunteered for another charity called the Prisoners Advice Service, and for people, which is a charity that provides advice to people in prison, primarily via letter. So prisoners would write letters asking for information and advice on the term of their sentence or the facilities that they were entitled to access within their prison and things like that. And that was a really useful experience when I was then writing applications, because it was a bit of oral advocacy and it was some interaction with people who were at quite a unique place, sort of at the end of the criminal justice system. But it sort of enabled me to see some very real issues. So I just thought I'd flag that because it's not something that I see talked about all that much, but for an aspiring criminal barrister at the time, it was really, really useful. So I just wanted to highlight that, but yeah, happy to answer any more questions on any of that.
Thank you very much, Olivia. And that's a really great point that Olivia touches on there, actually, is, and part of the point of this meeting is to kind of really highlight to you all the range of opportunities across different sectors. So, of course, we've talked about two, and we're going to talk about a third in a minute with James's help. Very distinct jobs, but of course, there's a lots of different roles out there, and Olivia's highlighted one in the form of paralegaling, which a lot of people, there are a lot of pre-submitted questions actually in relation to other non-bar related and sometimes even non-legal related work and how useful that can be. And I, for one, certainly have found that they can be incredibly useful. I mean, I know somebody who got pupillage who talked quite a lot about working in John Lewis, because it was long hours, it was lots of customer interaction, it was lots of quite detailed, procedure in relation to some of the and warehouses and things. There are lots of different skills that you can deploy in jobs that are not necessarily at the bar or advocacy related. Obviously, most obviously in things like paralegaling jobs, but also charities are a great opportunity, as Olivia says, because quite often you get access to quite vulnerable people who often face quite complex problems, and you get given quite a lot of responsibility. Olivia's talked to us about a role where she was involved with prisoners, obviously supervised by a solicitor, as we know that is. But in terms of different areas, I know that if you're interested in commercial or civil jobs, that there's there's a charity that volunteers at the companies court that deals with people, I think, who are facing winding up proceedings or bankruptcy. I know that there's a charity that helps there. I know that if you're interested in education or public law sorts of things, there's the Schools Exclusion Project. There's, of course, the Free Representation Unit, which Jim talks about. If you're interested in the family bar, I know that lots of women's groups and refuges, for example, and there's also domestic violence charities, the National Centre for Domestic Violence, for example, that often look for caseworkers. And of course, there's the one that many of us have heard about, which is the Criminal Advice Bureau. And also, shameless plug, there is a charity that I happen to be the director of called Leducate, which aims to educate secondary school age students in their legal rights. So check out all of those wonderful charities on your search engine of choice. So yeah, I think that's really important, Olivia. Thank you for highlighting the point about charities, because I know that a lot of you will talk, and I can see there's lots of questions about specific jobs that people are doing or could do. But a stark reality of the situation is that actually volunteering is really a good way of managing to farm up that experience to be able to, as Jim says, make that real leap between 1 year of applications and the next. And of course, there's questions there about accessibility in terms of those of you that have to work in order to fund your lives, really. But certainly, if you can manage to squeeze in any charity work, it doesn't go amiss. And I promise this is in response to a question in the chat. The charity that I'm a director of is called Leducate. That's Leducate. That's another shameless plug, but I promise you it was an answer to a question in the chat. So thank you so much, Olivia. James, lastly, but no means leastly, it'd be great to hear from you about the judicial assistant job, your role at the Law Commission, and anything else you'd love to tell us about. So fire away, James.
Thank you, Adam. And I should say, I don't think there's any shame in plugging a charity whatsoever. So, you're off the hook for that. Yeah, I mean, before I talk about the judicial assistant job, I think I'd just like to echo what Jim was saying about the value of advocacy experience that you can get from working for charities like the Free Representation Unit and Leducate, and also a whole range of others. I think, as Adam was just saying, there are several of them which will specialize in different areas of law. So depending on what you want to go into, whether it's employment or various areas of public law or commercial law or personal injury, there will be one which caters to your interests and which will give you the opportunity to get some real advocacy experience. And I say real because it's important to remember that these are cases with real litigants, and they're before real tribunals. And that's one of the advantages, I think, that getting advocacy experience with one of these charities has over, say, mooting. And that's not to say that mooting isn't very good experience, and that's definitely something you should put on your CV, on your applications if you've done moots. But volunteering with the Free Representation Unit or with Advocate or any of the others is really valuable. So I've done about 5 cases with the FRU, and I've appeared in the employment tribunals several times. I've also appeared in the Social Security Chamber of the First Tier Tribunal and the Employment Appeals Tribunal as a FRU representative. And when I was appearing in the Employment Appeals Tribunal, I was actually before a High Court judge because they sit in the EAT. So that was terrifying, but it was also a fantastic experience, and it's an excellent talking point for interviews, whether they be pupillage interviews or interviews for other legal jobs. So I would really highly recommend volunteering at any of these charities. But moving on to my role as a judicial assistant, I applied for that because I thought it would be a really good way to spend a year while building on the experience that I'd had time to get as a GDL student. So I hadn't really done a huge amount of law, and I thought, well, before I really go into the mayhem of applying for pupillage, it would be good to have another year actually picking up some experience. And I thought, well, where better to get that experience than the Court of Appeal, which is dealing with a lot of really interesting points of law, and which is going to give me the opportunity to see the decision-making process at a very high level. So that was really my thinking. And the approach I took to applying to that was really thinking about what I might gain from working alongside judges and what kind of skills would be required of a judicial assistant. And so when I was applying, I placed quite a lot of emphasis on my legal research that I'd done as a FRU representation unit advocate. So drafting documents and researching points of law for the cases I was working on. But I also put a lot of emphasis on having to deal with litigants in person, because what people don't always realize about the Court of Appeal and about sort of senior courts in this country is that there will be a lot of unrepresented litigants who don't have a swanky barrister from a top commercial chambers, for instance, and who won't really know how to fill out the relevant forms and put together the relevant documents like witness statements and particulars of claim and everything else. So having someone who has gone through a lot of documents with a litigant in person, who's not experienced with the process, is one of the things they look for when doing the paper sift and when generally selecting for judicial assistants. So I think that was another thing which really which helped me, and which was also a factor in deciding to apply. And in terms of the day-to-day role and what it involved, it involves a lot of producing an analysis of a case that a judge is going to sit on, going over all the bundles, summarizing the facts, summarizing counsel submissions, and then giving a short opinion on how you think the case should be decided. So there's quite a satisfying opportunity in the role, not only to sort of summarize the case, but also to have your own input and potentially try and influence the outcome of a case from behind the scenes. I don't say that in an illegitimate way, but that's one of the things you can try and do. You can have a discussion with the judges in a post-court meeting after hearings and see if you can try and get your point of view across in a persuasive way. So really, I think it's an excellent experience for learning what amounts to good advocacy by seeing some top barristers in the Court of Appeal giving their submissions, and for learning how to get on with judges, learning how to speak to them and the way in which they think. So overall, I would very much recommend applying for that job, applying for any kind of a judicial assistant role if you are looking to pursue a career at the bar, or if you're looking to go into another area of law, or if you're not even sure and you're just looking for something to fill a year, which is an absolutely fair reason to apply. So it's certainly going to strengthen any CV. But finally, before I give up the floor, I will just add to what Olivia has said about working at the Law Commission, which is where I am now. And I am working in the commercial team. So most of what I'm doing relates to crypto assets and digital assets, and how we should create legislation to regulate the use of crypto assets, digital assets, and also how we can change the law of intangible of property as it relates to intangible things. So a lot of trade is conducted with documents that are basically an embodiment of a right to the goods that they relate to. So when you're shipping, I don't know, lots of bananas, you're going to be transferring a bill of lading in physical form, which is an embodiment of the right to that consignment of bananas. But lots of people nowadays want to do a trade with electronic documents because it's much easier, especially throughout the pandemic. People have not wanted to come into contact with people. They haven't wanted to, and they haven't been able to come into hand-to-hand contact with people. So the law now needs to change to allow documents which can transfer rights to goods to be transferred in electronic form, and for those electronic documents to have the same effect as the paper ones. It may seem surprising that they don't already. It's a little strange, but it's a feature of English property law that you have to have a possession over something in order to have a property right over it. So in the case of, apart from some exceptions, but in the case of international trade, it's crucial that you are able to possess the document that relates to your goods. So I'm not going to pretend that the work I'm doing at Law Commission is that much like what you would have in practice as a barrister. I think it's quite academic and analytical in a way which practice probably isn't. But I suppose it just goes to show that you can have a very broad range of work on offer at the Law Commission. And so pretty much whatever your interests are, there's probably going to be a project which meets those interests. And so you should definitely look into applying. The application window for the next intake has just closed, but for future years, you should definitely look into applying to the Law Commission, because it's a very fulfilling work environment, and there's a huge range of projects to meet all interests.
Thank you so much, James. You've actually got a couple of questions targeted to you this evening. So prize to you for being the most popular target of questions. The most pertinent one for now is asked by William, who asks you, how competitive is the application process to become a judicial assistant? If you know, I mean, it may well be that you don't know the numbers of applicants, etc. But how competitive did you find the process relative to other things you've applied for, perhaps?
I think it is quite competitive. I think that there are between 600 and 1,000 applications a year, typically, and there are about 25 judicial assistants taken on each year. So it is quite competitive, but if you do the maths on that, if you're in a year when it's closer to 600 applicants, your odds are probably better than applying for pupillage at a lot of chambers, where you might have, 300 applications for 2 places. So it's not perhaps the most competitive thing if you're looking to pursue a career at the bar. That's not saying much, because obviously pursuing a career at the bar is a competitive business. But yeah, I mean, I think those are the figures. And I would say that, I mean, you can maximize your chances by reading the rubric and targeting the answers you give in the application form to civil service competencies, because after all, although you're working closely with judges, with the judiciary, this is actually a role which is administered by the government, by the Ministry of Justice, and so they have a particular way of assessing candidates, of recruiting people, which is in line with competencies, which you're probably familiar with, which are things, sort of behaviors, as they call them, and technical skills, like working in teams and working under pressure and at pace, and all these sorts of things, which are usually answered with a STAR, situation, task, action, result answer format. So I would say think about what the role involves, but also think about that slightly more mundane aspect of applications based on the civil service competencies.
Great, thank you so much, James. I think that brings our sort of descriptive job talking about aspect to a close, and I think we've got about 15 minutes or so to give some general insights, and potentially a little bit longer if absolutely required, but certainly giving insights now into our experiences in relation to actually answering Pupillage gateway forms, and giving some general tips in relation to that. Jim has his hand up. Oh,
thanks.
Yeah,
no, it was just to cover the application process for LPC law, because I neglected to do that.
Yeah.
And I'll do it very briefly. Essentially, there's a pro form application form you fill in. If you get through that stage, they invite you to an interview, which, as I recall, was a mock advocacy exercise. After that, you then have to do compulsory training, and then you're good to start work. And I should also say Quest Legal, amongst others, are similar institutions that offer the same thing. DWF, I think, also does something similar.
Yes, Jim, just ensuring broadcasting lack of bias there. So there you go. None of us are paid to promote any of the organizations that we happen to be espousing about. It's just they might have paid us at some point in our not so distant careers. So there you go.
I think blowing the trumpet for a charity wins you slightly more points than me, but yes.
So I'm going to ask this question of everybody, actually. And James, feel free to not answer if you don't want to, but I'll start with you, Olivia. What do you think the 2 or 3 core qualities of a barrister are that applicants should highlight? So how would you, do you think, answer that question in relation to 2 to 3 core qualities of a barrister that you highlighted during your application? Can you help our audience with that?
Yeah, of course. I think it potentially slightly depends on the area of law that you're applying for, but perhaps it shouldn't. But I think that's a really good question, and focusing answers in terms of sort of core principles and then corralling your evidence around that, I think is a really good approach. And I think that's something I did even where the question didn't necessarily ask it in those terms. So things like, why do you want to be a barrister, or why this chamber, so things like that, where there's sort of no structure at all. I think this is a format that I actually used, and I am struggling to remember the exact 3 that I gave, but I always for criminal law, the 3 that I kind of, the broad 3, perhaps not in so many words, that I settled on were integrity, some form of interpersonal skills or emotional intelligence or ability to work with people in sort of real life settings. I'm sure there's a much pithier way of saying that one. And the third one was, and another sort of core principle was ability to sort of deal with the material intellectually, but also to have the motivation to deal with it. So that's probably 4, just to give you a range. But I sort of examined everything that I knew about the bar from people that I had spoken to and worked with, and shadowed and everything like that, and tried to, just based on my own experience, so that I could talk about them sort of genuinely and with conviction, just drill down the sort of themes that I thought ran through what I had seen and what I understood to be important, and then what sort of people asked me in interviews that I also surmised were probably quite important, and things like that. But along those lines, for me, felt appropriate. So as an example, I hope that's helpful.
Yeah, thank you very much, Olivia. Actually, to contribute to the discussion myself, my 3 for budding family lawyers when I was applying was that I thought it was important to be emotionally intelligent, able to make decisions, and capable of hard work. Those are my 3 qualities. And I broadly structured that box around that. And as Olivia says, I think it's really important to think of those qualities in the sense of what you can evidence. Obviously, it's great for you to think that somebody's emotionally intelligent or that you're capable of hard work. But if you haven't done anything that demonstrates emotional intelligence, or done anything, which I'm sure none of you have not done anything that doesn't demonstrate hard work. But for example, it's better to pick qualities that demonstrate, you can demonstrate. And if you think those qualities are important, you can't demonstrate them, I think it's a good metric for where you should go and plug those gaps and work that you should go and get. So yeah, those are my 3 qualities: emotionally intelligent, decision maker, and being capable of hard work. So those are my 3. Jim, what were yours?
I'm not sure if I'd be able to list a particular 3. I think it would depend what would come to mind at various interviews. But I'd echo what you both said about the stories. The best advice I think I got when applying was knowing your sort of 6 or 7 best anecdotes, and understanding how you can apply them to answer different questions. And I got into a stage where I thought, every interview is a pitch. And if I haven't used my best anecdotes, then I probably haven't given my best pitch. And I think the same is true for a lot of application forms. So depending what the other questions of the application form are, there's anecdotes you haven't used and which you can use to demonstrate a particular talent. And by anecdotes, I obviously mean experiences. Then I think that perhaps would help in drafting, at the very least, to find your answer. I suppose if I had to choose 3, I think integrity, hard work, and empathy.
Thank you, Jim. James, I'll spare you that question. I think, unless you want to answer it.
No, I'm happy to sit that one out.
Yeah, no worries.
You've had excellent answers, so I think I'll leave it with them.
No worries at all. We've got another interesting question here, actually, something that I get asked a lot, which is, should you name drop people who you've shadowed in mini pupillages in your response to that chambers? And I think this is also more widely because I've been asked, should you specifically name members of chambers when you say why chambers, or, and another question I've got here that I'm going to amalgamate. And sorry, I can't tell you who asked these questions because they're anonymous, but thank you to the 2 anonymous people for asking those questions. The second question is, when referring to cases that you find interesting, should you tailor yourself towards a case that was done by that chambers, or should you pick another? So, I mean, for my response, while the other panelists think about that, I mean, I personally have always name dropped the names of specific barristers that I've done many pupillages with, especially if applying to that set of chambers, because it shows you've met members of chambers. If I was on a panel, I'm not, but if I was on a panel, I would be interested to know which member of chambers somebody saw, because it gives me an instant snapshot and an insight into what areas of practice they looked at, what qualities I know that barrister to have, and therefore what I know that they would have seen of our chamber's life and how typical that barrister's work is, for example, of the work Harcourt does. For example, when I wrote my applications to individual chambers and when it said why chambers, I specifically said, X person is the head of chambers, they do Y kinds of work. I really aspire to that kind of work, towards the end of my career. But I also looked at who the juniors were. So I said, I'm really inspired by the fact that at Harcourt Chambers, you've got a whole plethora of juniors that get exposed to a lot of senior work quite quickly, who seem to have won awards or indeed have lots of things to talk about on their profiles about pro bono work, which is something that's particularly important to me. And I relish the opportunity to become one of those juniors, doing lots of senior work quite quickly, having a good carve out of time for pro bono while having a career progression into an area of work that I'm interested in. So, you know, when you're answering these questions, remember it's one massive piece of advocacy where you are trying to convince these chambers you know everything about them, that you know what life at that chambers entails, and that you want in. And that not only do you want in, you're going to make them, i.e. the clerks and the other barristers, you're going to make the clerks some money, and you're not going to embarrass the other members, which is fundamentally, in my view anyway, the approach I took. But Jim, I don't know if you want to build on any of that yourself.
I'd agree with it. I think I don't think I've got anything particularly useful to add. I think that was a good answer.
Thanks. Olivia, anything you'd like to say?
I sympathise with this question because I received conflicting advice when I asked people this question when I was applying. I've been told that it is a good idea and not a good idea. So I sort of think it's maybe a cop-out. The most important thing, the conclusion that I came to, was that it was about what I felt comfortable with, because it seemed to be that there wasn't necessarily a complete consensus on what the best thing to do is. And I hope it's reassuring that I got interviews off the back of applications in which I did and did not name drop people, depending on how sort of well or not I knew them, and all sorts of things like that. But I did name drop in some, just where it felt like what I was saying without it, as much as anything, sounded a little bit vague and wasn't necessarily making the point that I wanted it to make. And I think Adam's point that I hadn't necessarily thought about before is a good one, that it gives chambers a reference point for what you're talking about, because obviously they will be familiar with that person, and however you've interacted with them or what you've read about them or anything like that, they will then have a sort of a better idea of what you're talking about, if that's if you're using them to sort of make a point or whatever. And I think that's a really good point. But for me, it's just about comfort, what you're comfortable with. But I don't think either is right or wrong.
Great, thanks. And James, I think your view here would be appreciated by the audience as a whole, just as another opinion in the round. What do you think?
I think I agree with you, Adam. I think that it makes sense to name drop barristers. I think that from a cynical perspective, a lot of barristers, you know, they have big egos. They like to see their names, or they like to see that you have taken an interest in their work, and it may well be, you know, that it's them marking your application, or that they'll be on the interview panel. And I think you can probably score some points just by having mentioned them and expressed an interest in their work, if they are interviewing you or if they are assessing you at any stage of the process. But also I think that it just goes to show that you haven't done a complete copy paste job on your applications, because if you've mentioned barristers from their chambers, it's showing that you've tailored them and that you've given thought to the application. So I think that must be something which chambers have to deal with. You know, a lot of applications from people who, for one reason or another, have just done a copy paste job, and they'll find, you know, the other chambers' names somewhere in the answers. So if you have included the names of barristers from their chambers, I suppose it gives them some reassurance that you've actually spent time on the application, you are serious about them.
Thank you, James. Yes, I think I have to echo that entirely. It is all about demonstrating your desire to apply to that chamber's in particular. So yes, thanks all for that questions. I'm just going to mop up, if I can, and they're going to be some quite random topics I think I'm going to be addressing for you all, but I'll address them sort of in a chunk, and then if the panelists, if any of you guys want to jump in, just feel free to do so. So one question comes, and I know we've got a lot of international students online today who are joining us, or certainly people from international backgrounds. And this is a question about those who are transferring lawyers from other jurisdictions. And it's a question about having practiced law in America for 4 years in domestic violence law, in family and criminal court, and being called recently to the England and Wales bar. And the question is it imperative to obtain experience in English law related positions before applying to pupillage? And whether any of us on the panel have any experience with working with transferring lawyers. Now, I certainly don't have any experience with any transferring lawyers necessarily that I know of, but I think this threads back into some of the stuff we've heard from the panel earlier this evening, and certainly what I've been saying, which is that any experience is good experience. Any experience that gives you skills, and all of the jobs you've heard about tonight are such a range of jobs, being from research, judgment writing or influencing, as James has been saying, or advocacy, as Jim's talked about. These are all skills that you derive from jobs that are all very different to each other, but all fundamentally give you the full package that makes you into a barrister. And the unique thing, I think, in my view, about this job and about the process from leaving university is that some people will join grad schemes when they leave university, but the joy of this job is we get to cook up our own. We get to pick our own experiences and follow our own paths to develop the skills we think we'd like to develop and the ones we think we need. So just because you've done that in another country certainly doesn't preclude you from putting that kind of stuff on your form. Another very interesting question that we've had relates to the activities and interests box, which I know is a thorny issue for many people applying to pupillage. And it's essentially, what do you put in your activities and interests box, and how useful is it? Now, my advice, and I think it'll be great to hear from other members of the panel on this one as well, is that I was certainly always told that the activities and interest box is your opportunity to really talk about you, about the things that make you an interesting person. Because if you think about it, we can all tell that Jim is pulling an all-nighter, or certainly a late one, and has to spend probably a long time at chambers, or indeed any of us have to spend a lot of time at our desks. And it's very nice to know that the person you have to share a room with, often in quite close quarters in Temple, is somebody you can get on with, or at least somebody who's interesting, and certainly somebody that's not going to bore you to death if you're sat on a train with them for 2 hours to Maidstone County Court on a Thursday or something like that. So having the activities and interest box really gives you an opportunity to shine. But also, if you can, remember that the whole form is an opportunity to tell a set of chambers why you are the perfect barrister. And I'll give you an example. I know somebody who talked about their extensive career in rugby. And they used the fact that they used to have to get up 3 mornings a week at 6 o'clock in the morning to go out in the wind and rain as an example of how they are dedicated to teamwork and capable of hard work and capable of powering through adversity. So if somebody can talk about rugby in such a way as to make their barrister career sound more plausible, then I'm sure that there's hope for us all. I don't know if any of you, Jim or Olivia, or indeed James, if any of you want to jump in on the activities and interest box. Jim first.
Yeah, I think it goes to showing a little bit about yourself. I remember the career advisor at ULaw saying something helpful. When you get that question in an interview, certainly it's a chance to make the panel laugh. The one opportunity you have where you don't just need to give a analytically sound answer. Pretty much anything you say, as long as it tells the panel a bit about yourself, is probably helpful. But as you learn your anecdotes, I'm sure there'll be a way of drawing the answer into one of the competencies. But sometimes it's just saying, you know what, when I finish work, here's something that I can do and I will remain sane. This is how I recharge. And there's 1 or 2 things a week that I do and will continue doing. And I'm not going to burn out because I have those other interests.
James, your thoughts?
Yeah, absolutely. I'd echo that. I think that it makes sense to just show that there's a bit of depth to your personality above and beyond your ability to do the job. And, it's like Adam was saying, if you're going to be going on a train with someone to a county court somewhere, you want to know you're going to get on with members of chambers, that they're personable. That's, the people who are interviewing you are, they're human beings at the end of the day, and that's a big part of working with other people, like getting on with them. So yeah, I suppose anything which adds a bit of interest. Also, I suppose because you're more likely to say something which is going to stand out in your interests section, perhaps, than in the other sections, because the other sections will, everyone's answers will be within a sort of a fairly limited range. People have done moots or through or like done this module at whatever university, but you're more likely to have something which they haven't seen before in that box, which they'll be like, oh, okay, that's kind of cool. So I suppose, yeah, don't waste that opportunity, because it might be that the only thing that sticks in their head is that you were like you're interested in hedge topiary, like manicuring hedges or something like that. So that might be the big hit which gets you the pupillage, who knows?
Yeah, I can say that my one of my activities and interests box points that I once appeared as an extra on the popular television show EastEnders made it into the Chambers quiz the year that I was the pupil. So clearly it was so memorable that it stuck in the minds of whoever drew up the Chambers quiz. So these things really are remembered, and these things really do stick in people's minds. So Olivia, yes, how would you address the activities and interest box, or how did you address it? Because you never have to do it again, thankfully.
I echo what's been said completely. I found this question really difficult. I applied for pupillage twice, and in my first year, I'm not suggesting this is wrong, but it wasn't the right approach for me. I tried to contrive that something that actually I did to build my CV for pupillage was sort of like an interest outside of work that I chose to do completely voluntarily, and it didn't probably was not the only reason I didn't get pupillage. But the following year I gave a very genuine answer, very similar to Jim. I took the approach that when I'm in pupillage and beyond, there will be things that I do to relax from the stresses of the job, and they are probably more interesting anyway to talk about. So I was quite honest. And then in one of my final rounds that I got an offer from, I was asked at the end a question about what my favorite vegan meal would be, or what I would recommend for someone who's not a vegan to have as the best vegan meal. And I panicked for a second because I didn't know how they knew that I was vegan, and I thought it was a really weird question. And then I suddenly remembered that I had talked that it had been one of the things I talked about, and we had a big joke about it, and it was, as much as anything, really enjoyable. But I think cynically it also helped. So I advocate for being honest about what your actual interests are and entertaining them.
Yes, it really does help, I think, having something, as Jim and Olivia both alluded to laugh about in an interview, because otherwise, it staves off the crying that inevitably happens on the way home. So thank you, everyone. In terms of my closing remarks, I just want to spend a couple of minutes on some encouraging words, I hope, about resilience in the process, because I'm aware that I think that the gateway closes this coming weekend, and that interviews will start flowing in for some of you thick and fast, and for other of you they won't. For some of you, you will get many first round interviews, and you may not convert many of them into second round interviews. And you may well convert some of them into second round interviews, but not into offers. From my own anecdotal experience, when I applied in my successful rounds, I applied for 2 rounds, twice, back-to-back years. In my second year of applying, I had 5 first round interviews, only 1 second round interview, and that second round interview ended up becoming an offer. So when people tell you, or you read it on forums, that you only need 1 interview to be able to get pupillage, it's true, because I am the living, breathing proof that you can have 1 second round interview and you can get 1 offer. So every interview really does count. Prepare as thoroughly as you can for them, but also bear in mind and remember it's a 2-way street. It's very much the analogy I always use to death, which people are always sick of me using, but is that analogy of you are essentially a car salesperson, but the disadvantage you have is you only have 1 car to sell. And if somebody walks into your car sales room and is looking for a sports car, but you only have a 4x4 to sell, then all you can do is try your hardest to convince that person that your 4x4 is the one they want. But if they have their hearts set on a sports car and you only have a 4x4, then that person you and that person don't make a sale, they walk away, and you're still left with your 4x4. But as that salesperson, as that plucky young salesperson, as I encourage you all to be, keep trying to sell that 4x4, because I guarantee you, in the 5 years allotted to you by the Bar Standards Board, I have great hope that through persistence, sheer persistence, hard work, plugging those gaps, using some of the examples that that our panelists have furnished you with of charities, jobs, roles within all of the jobs we've talked about, you really can build yourself up to be the vehicle that your chambers is looking to buy, essentially, to do the analogy to death. It certainly is. You know, many of you will have great qualities, will be fantastic lawyers of all different shades. But, you know, in that 1 year, that panel may not think you're for them, and you actually may, on reflection, think that that set of chambers wasn't for you either. Many of you will have dream sets that you wish you could be at, and many of you will get there, but some of you will end up somewhere else. And let me tell you that being at a set that I hadn't previously considered before applying there, I'm very happy where I am, and I look forward, hopefully, to not getting disbarred in the near future and having an enjoyable career with them. But I say all of this because I encourage you not actually to look at statistics of how many people apply for pupillage in a year and how many people get it, because for various reasons there's a lot of skew to those statistics, and a lot of people who apply prematurely or speculatively that skews all of the statistics. Run your own race, make your own application, put in your application what you're comfortable to put in there, speak to it, because it's yours. It's your life condensed into 300 words in a box. But all I can wish you is the best of luck. I'm sure that's echoed by the rest of this panel. And if any of us, you come across any of us in our professional lives in any way that we can provide you additional assistance or anything else, I'm sure that we'll happily do what we can to help you. I can only commend the Lincoln's Inn Education Department for all the work that they do and all the support that they provide to members. If any of you are eligible, I know that the criteria has changed, but if any of you are eligible in future years and not successful in the coming year, I really do suggest, if it's still running, apply for the foundation scheme, the Pupillage Foundation scheme, if you're eligible, because it was a fantastic course, fantastic resource that the Inn has specific to itself. I don't think any other Inn has as comprehensive a course as Lincoln's Inn does in relation to pupillage support. So if you're not successful this year, please do check out that course. But I do know that many members and staff and the department as a whole are always available to help you all. So I hope this event has been useful. Thank you so much for coming. And I think the lights are coming on, so it's time to go home. So thank you all for coming, and I hope it was very useful.
I'd just like to